Today, we need to talk about something massive that is going to fundamentally change how personal defense works in the state of California. If you live here, if you carry here, or if you're even thinking about getting a CCW permit, you need to pay close attention. We are diving deep into the massive updates and restrictions coming in 2026, specifically Senate Bill 2. The question is simple. Can you still carry? The short answer is yes, you can. But where and how is about to get a whole lot more complicated, confusing, and frankly, restrictive. For years, California has been moving the goalposts on Second Amendment rights. But SB 2, set to take effect in January 2026, after some court challenges, is a game changer. It drastically expands the list of so-called sensitive places, where even licensed CCW holders are prohibited from carrying. This isn't just about courthouses and schools anymore. We're talking about almost everywhere you might go in your daily life. To understand the impact, let us break down exactly what SB 2 does and why it feels like the state is trying to nullify the Supreme Court's ruling in Brunei. First up, the training requirements are changing. We're moving from a minimum of 8 hours of training up to a whopping 16 hours. That's double the commitment, doubling the cost, and significantly raising the barrier to entry for responsible gun owners. And it's not just the classroom time, they've also ramped up the live fire component, mandating qualification with every type of firearm you intend to carry. This shows a clear intent to make the licensing process more arduous and expensive. But the real meat of SB 2, the part that is generating the most controversy and confusion, is the sensitive places list. Before SB 2, a CCW generally allowed you to carry unless specifically prohibited. Post SB 2, it seems almost the opposite is true. The new law blankets vast swaths of public and private property as off-limits. Let us look at some key examples of where your CCW permit will effectively be useless come 2026. Think about parks, playgrounds, public transportation, places of worship, banks, zoos, libraries, museums, stadiums, and basically any place where the public gathers. The list is extensive, and it's intentionally broad. For instance, any establishment that sells alcohol for consumption on the premises, that means restaurants, bars, breweries, all prohibited. If you live in a city, good luck finding a block that doesn't border one of these sensitive locations. Now, let's talk about private property. Think about the implications of that for your daily errands. You pull up to the grocery store, the hardware store, or the local dry cleaner. If they don't have a specific sign saying concealed carry permitted here, you are in violation of the law if you enter with your firearm. The burden of proof, the burden of checking, and the risk of criminal charges all fall squarely on the law-abiding CCW holder. And let's be honest, how many businesses are truly going to put up signs actively inviting people to carry firearms? Very few, if any. This provision alone could effectively disarm CCW holders in almost all commercial settings. So, where can you still carry? Essentially, outside of the sensitive places, outside of these private commercial properties that haven't posted the right sign, and inside your own home or private residential property. The reality is that the usable footprint of your CCW permit is shrinking dramatically. For many urban and suburban residents, traveling from home to work or running basic errands will now involve navigating a complex minefield of prohibited zones. Now I know what you're thinking. Is this even constitutional? And that's where the legal battles come in. SB 2 was signed into law, but it immediately faced fierce legal challenges, primarily arguing that it violates the Second Amendment as interpreted by the Supreme Court in Brunei. The core issue is whether these restrictions are consistent with the nation's historical tradition of firearm regulation. Opponents argue that these sweeping prohibitions on carrying in public are completely unprecedented historically. Initially, a federal judge blocked SB 2, calling it unconstitutional. That was a huge, temporary win for gun rights advocates. However, the state of California immediately appealed, and a panel of the Ninth Circuit Court of Appeals eventually stepped in, allowing the law to go back into effect while the full case proceeds. This legal back and forth means that even though the law is currently enforceable, the final decision is still up in the air and likely headed back to the Supreme Court. But here's the critical part for you, the CCW holder. Until a court permanently strikes down SB 2, the law is the law. And the operative date we are focused on is January 1st, 2026. As we get closer to that date, you need to understand the new landscape. Let's discuss the consequences of non-compliance. If you are caught carrying in a prohibited sensitive place or on private commercial property without the affirmative permission sign, you could face misdemeanor charges. While a misdemeanor might sound light, it means fines, potential jail time, and revocation of your CCW permit. The state has made it clear that they intend to enforce these new rules strictly. For those considering applying for a CCW SB, to also introduces new suitability requirements. Beyond the existing good moral character standard, the law now mandates interviews and the disclosure of extensive personal information, including social media accounts for review. This further centralizes the licensing authority and allows for subjective denial based on perceived lack of suitability. This means they are looking not just at your criminal record, but at your online persona and associations to determine if you are fit to exercise this right. So, what should you be doing right now? First, if you are a current CCW holder, you need to dedicate time to mastering the new map of sensitive locations. Understand where you can and cannot go. You need to develop a serious habit of checking for those explicit permitted carry signs before entering any commercial establishment. If you don't see one, you must assume carrying is prohibited. Second, be prepared for the increased cost and time investment for renewal training. Start planning for that 16-hour commitment now. Third, stay informed about the legal status of SB2. This is a dynamic situation. The outcome of the legal challenges will dictate the final form of California's CCW law. Follow reliable legal sources and organizations dedicated to protecting Second Amendment rights in the state. If the injunction is reinstated, or if the Supreme Court takes the case, the rules could change again rapidly. The bottom line is that California is making it abundantly clear that they want to discourage concealed carry. SB2 is designed to create a system where exercising your right to self-defense in public is so confusing and risky that most people will choose not to do it. This fight is far from over, both in the courts and in the legislature. It's absolutely critical that responsible gun owners in California remain engaged, informed, and compliant with the laws as they stand, while also supporting the legal efforts to restore constitutionally protected rights. Your self-defense rights are changing, and being ignorant of the changes is simply not an option. Thank you for tuning in and staying vigilant on this incredibly important issue. If this information was helpful, please hit that like button, subscribe for more updates, and drop a comment below letting me know how these 2026 changes will impact your daily life. Stay safe out there, and I'll catch you in the next video.